Welcome to the law enforcement agencies and custodial crimes against women and children. When one considers the aspect of custodial crimes committed by the law enforcement agencies, one will certainly come across the powers of the police, as it is mostly the police which has the power to arrest and take a person into custody in exercise of their powers conferred by the Code of Criminal Procedure 1973. Apart from the police, there are several other authorities also, like the Director of Revenue Intelligence, Directorate of Enforcement, Coastal Guard, Central Reserve Police Force, Border Security Force, Railway Protection Force, Central Industrial Security Force, the State Armed Police, and intelligence agencies like the Intelligence Bureau, Central Bureau of Investigation, CID, Traffic Police, Mounted Police, and the Indo-Tibetan Border Police. They also have the power to detain a person and to interrogate such person in connection with the investigation of the economic offences, Excise and Customs Act, Foreign Exchange Regulation Act, etc. There is a reported case in the date of Sawinder Singh Grover, 1995 supplement, volume 4 SCC, page number 450, when the Supreme Court took suo motu notice of the death of Sawinder Singh Grover during his custody with the Directorate of Enforcement. After getting an inquiry conducted by the Additional District Judge, which disclosed a prima facie case for investigation and prosecution, the Supreme Court directed the CBI to lodge an FIR and initiate criminal proceedings against all persons named in the report of the Additional District Judge and to proceed against them. The Union of India Directorate of Enforcement was also directed to pay a sum of rupees 2 lakhs to the widow of the deceased by way of ex gratia payment at the interim stage. This is an example of the custodial violence, but not against a woman or child. The custodial violence is mostly done by the police and the army, who act in aid of civil power, as the police is given enormous powers to arrest and take a person into custody by the Code of Criminal Procedure of this land. The moment custodial crime against women is under consideration, one cannot forget the Supreme Court judgment being Tukaram versus State of Maharashtra, 1979, 2 SCC, page number 143. Mathura, a young tribal girl of 16 of a village in Maharashtra, was in love with a boy and wanted to marry him. Her elder brother objected and lodged a complaint at the Desaigarh police station, stating that the boy had kidnapped Mathura. At about 9 in the night, the boy with his family members and Mathura were brought to the police station on 26 March 1972. The police recorded statements of all and released except Mathura and took her inside the police room, and Ganapat raped Mathura in the toilet, and the police constable Tukaram molested her. By this time, the boy was waiting outside helplessly. An angry crowd collected together outside the police station and a complaint against the policeman was lodged. Mathura was medically examined. The trial began. The Sessions Court declared the policeman innocent by holding that even if there was sexual intercourse, there was no rape because there was no proof that Mathura had resisted the Bombay High Court reversed the finding and sentenced Tukaram and Ganpat on the ground that these two accused persons are totally strangers to Mathura. It was highly unlikely that she would invite them to satisfy her sexual desire, nor could she have resisted the assailants. They have taken advantage of her lone helplessness inside the police station in the dead hour of night. The policemen went in the appeal before the Supreme Court of India, and the highest court of justice acquitted the two policemen. The reasoning of the Supreme Court in substance was that since she did not resist, she must have consented. 4 law teachers, namely Professor Upendra Bakshi, Dr. Basudha Dhagamwar, Raghunath Kelkar and Lotika Sarkar, wrote an open letter addressed to the Chief Justice of India with the opening line that was an extraordinary decision sacrificing human rights of women under the law and the Constitution of India. The Indian Penal Code was amended in 1983 and provided inter alia in section 376, subsection 2, whoever being a police officer commits rape within the limits of the police station to which the police officer is appointed, or in the premises of any station house, or on a woman in such police officer's custody, or in the custody of the police officer subordinate to such police officer, shall be punished with rigorous imprisonment for a term which shall be not less than 10 years, but which may extend to imprisonment for the life, which means imprisonment for the life, remainder of the person's natural life, and shall also be liable to fine. In the same year, the Indian Evidence Act 1872 was amended in section 114A. The provision lays down that where sexual intercourse by the accused is proved, and the question is whether it was without consent of the woman alleged to have been raped, and such woman states in her evidence before the court that she did not consent, the court shall presume that she did not consent. In view of this amendment, the Mathura case is no longer good law of this land and only a history now. As regards custodial crimes against women, one cannot keep aside another reported case decided by the Supreme Court of India. In Shila Barsev, State of Maharashtra, AIR 1983, Supreme Court 378, Justice P.N. Bhagwati, as he then was, on behalf of the 3 judges' bench, entertained a writ petition based on a letter written by a journalist complaining custodial violence on women prisoners while confined in the police custody in police lockup in the city of Bombay. The court directed a fact-finding team to visit the Bombay Central Jail and interview the women prisoners as to whether they have been subjected to any torture or ill treatment, and to submit a report. Based on the report that there was no adequate arrangement for providing legal assistance to women prisoners, the Supreme Court bench issued directions amongst others as follows: to lock up female only in the female lockup guarded by female constables, and to interrogate female prisoners only in the presence of female police officers. In this case, the Supreme Court took note of the fact that custodial violence extends to women and custodial crimes are seen to be committed against women as well. women and children are considered to be vulnerable section of the society, and taking of this fact that the constitution makers provided in Article 15 clause 3 that state is not prevented from making special provision for women and children. There has been long legal tradition introduced by the Constitution of India empowering the states to make special provision for women and children. A fundamental duty has also been imposed on all the citizens to renounce practices derogatory to the dignity of women. In keeping tract with these directions, there has been maintenance of a long tradition of not arresting women in absence of a female constable. A number of cases have been lauded where arrests of women have been made in violation of such tradition or instruction. There have been no case of prosecution of such involved armed personnel who resort to arresting women in violation of such a mandate. Departing from a long tradition of not arresting women at night and not arresting women in absence of a female constable, the Supreme Court of India in the state of Maharashtra versus Christian Community Welfare Council of India, 2003, volume 3, SCC, page number 546, held. Herein we notice that the mandate issued by the High Court prevents the police from arresting a lady without presence of a lady constable. The said direction also prohibits arrest of a lady after sunset and before sunrise under any circumstances. We think a strict compliance with the said direction in a given circumstance would cause practical difficulties to the investigating agency and might even give rooms for evading the process of law by unscrupulous accused. While it is necessary to protect the female sought to be arrested by the police from police misdeeds, it may not always be possible and practical to have presence of a lady constable when the necessity for such arrest arises. Therefore, we think this direction requires some modification without disturbing the object behind the same. We think the object will be served if a direction is issued to the arresting authority that while arresting a female person, all efforts should be made to keep a lady constable present, but in circumstances where arresting officers are reasonably satisfied that such presence of a lady constable is not available or possible, and or the delay in arresting caused by securing the presence of a lady constable would impede the course of investigation, such arresting officer, for reasons to be recorded either before the arrest or immediately after the arrest, be permitted to arrest a female person for lawful reasons at any time of the day or night, depending on the circumstances of the case, even without the presence of a lady constable. This is clear dilution of criminal law protection of arrests of women by the police. However, by the Criminal Law Amendment Act 2009, the judgment is superseded and provisions have been made in the Code of Criminal Procedure 1973. Herein, after referred to as the CRPC, which laying down the procedure of the arrest of the women, it is provided that except in exceptional circumstances, no woman shall be arrested after sunset or before sunrise, and where such exceptional circumstances exist, the woman police officer shall, by making a written report, obtain the prior permission of the judicial magistrate of first class within whose jurisdiction the offence is committed or arrest is to be made. Unless the police officer is a woman, the police officer shall not touch the woman for making her arrest. This is laid down in section 46 CRPC. Whenever it is necessary to cause a female to be searched, the search shall be made by another female with strict regard to decency. And section 60 A provides that no arrest shall be made except in accordance with the provisions of CRPC or under any other law providing for arrests. In the matters relating to examination of witnesses by the police, popularly known as 161 evidence, recorded under section 161 CRPC, a special provision is enacted that the statement of a woman against whom an offence under section 354, section 354A, section 376B, section 376C, section 376D, section 376E or section 509 of the Indian Penal Code is alleged to have been committed or attempted shall be recorded by a woman police officer. Under section 166A of the Indian Penal Code, it prescribes punishment to public servant who knowingly disobeys any direction of the law which prohibits him from requiring the attendance at any place of any person for the purpose of investigation into an offence, or knowingly disobeys to the prejudice of any person any other direction of law regulating the manner in which he shall conduct his investigation, or fails to record any information given him under section 154 CRPC to register an FIR in relation to cognizable offence punishable under section, amongst others, section 354, section 354A, section 354B, section 370, section 370A, section 376, section 376A, section 376B, section 376C, section 376D, section 376E or section 509 of the Indian Penal Code, shall be punished with rigorous imprisonment for a term which shall not be less than 6 months but may extend to 2 years and shall also be liable to fine. The above provisions of the law are meant to be observed by the law enforcement agencies which relates to custodial crimes against women. Reported cases have shown that there is custodial violence against children. In Kadra Paharia versus State of Bihar, AIR 1981, Supreme Court 939, the Supreme Court of India received a letter from one researcher and social worker working in the Santhal Pargana in Bihar, on the basis of which a case has been registered. In that case, 4 children who were at the time of the arrest were naked goatherds of the age between 9 to 11 years were arrested and lodged in Pakur sub-jail in Santhal Pargana for a period of about 8 years without their trial having been made any progress. The court was apprised of the fact that the 4 children were found in leg irons. According to the letter, she learned on inquiry that the 4 children were to work outside the jail walls for fetching water and doing other duties to guard against the possibility of their running away. They were kept in the leg irons throughout inside the jail and during the lockup hours. The Supreme Court called an explanation from the superintendent of the Pakur sub-jail to explain as to why he kept the 4 prisoners in leg irons, contrary to the law of this land, and extract work from them. The court directed the superintendent to immediately remove the leg irons and set them free. At the time of the case, the 4 children are all aged more than 18 years of their age. The Juvenile Justice Care and Protection of the Children Act 2000 is the law and the relevant law relating to the child in need of care and protection and juvenile in conflict with law. for providing proper care, protection and treatment by catering to their development needs and by adopting a child-friendly approach in the adjudication and disposition of matters in the best interest of the children and for their ultimate rehabilitation. The term juvenile and the child is defined to mean a person who has not completed the age of 18 years of age. The Act has laid down that when a juvenile in conflict with law is apprehended by the police, the arrested juvenile is to be placed in the charge of the Special Juvenile Police Unit or designated police officer who shall immediately report the matter to the member of the Juvenile Justice Board. While a juvenile is placed in charge of the person, he shall have the control over the juvenile as he would have if he were his parents, and shall be responsible for his maintenance, and the juvenile shall continue in his charge for the period stated by the competent authority. When any juvenile is arrested, he may be released on bail and placed under the supervision of a probation officer. But when he is not released on bail, he shall be kept only in the observation home. Section 23 of the Act is relevant to the custodial violence towards a child. Whoever being the actual charge of or control over a juvenile or the child assaults, abandons, exposes or willfully neglects the juvenile or causes or procures him to be assaulted, abandoned, exposes or neglected in a manner likely to cause such juvenile or the child unnecessary mental or physical sufferings shall be punishable with imprisonment for a term which may extend to 6 months or fine or with both. Under this Act, Special Juvenile Police Unit is to be created after giving special instruction and training. In every police station, at least one officer with aptitude and appropriate training and orientation may be designated as the juvenile or child welfare officer, who will handle the juvenile or the child in coordination with the police. Special Juvenile Police Unit, of which all police officers designated as above to handle juvenile or children, will be members and may be created in every district and city to coordinate and to upgrade the police treatments of the juveniles and the children. Friends, it is the time to conclude. As regards the custodial violence of children by the law enforcement agencies, the Juvenile Justice, Care and Protection of Children Act 2000 has been made to be enforced, and to take care of such custodial violence towards the children, and the authorities are required to observe the provisions of that law, and in case of infraction of duties by the authorities, prosecution against the erring authority should not be spared to set an example. As regards custodial violence towards women, also the Code of Criminal Procedure and the penal law of this land enact various stringent provisions as seen above. Besides that, monetary compensation is also an appropriate and indeed an effective and sometimes perhaps the only suitable remedy for redressal of the grievances that may be faced in cases of custodial violence towards women and children.